Bring back in two of our finest legal minds to help us break this down. Bob Massi, Fox News legal analyst, and also Judge Alex Ferrer. Gentlemen, thanks for both sticking around. Judge, let me ask you, I mean, the delays that we've had a couple of times over the breaks where issues have come up, unusual, or is this par for the course?
Oh, no, it's not unusual at all. I mean, you know, you can have the best plans in the world, but something comes up, somebody is delayed, there's an issue that's raised. We saw a break where they were going over the demonstrative aids that Baez wanted to use, and the state had objections to them. Those should have been done before trial, but they weren't, so they had to be heard by the judge and ruled on before we got into closing arguments, and he showed them to the jury.
And Bob, if you're looking at this from a defense perspective, if Casey Anthony is convicted, we obviously expect an appeal. Any points that you see, any flaws potentially that the defense could use as a point for appeal?
Well, you know, again, besides somebody like Phil Keating, a judge, I haven't sat in there every day, but I will tell you that many times anything where there's exclusion of what's very relevant evidence that the defense feels that the jury had the right to know, or in fact evidence that was admitted that the jury feels that the judge felt that they should have not seen, or whatever that may be, that was prejudicial, things of that nature, many times that's a basis for an appeal. Again, I think the judge would know much better than me in Florida what kind of error there's going to have to be, but it's tough. You know, when you get a jury verdict, you know, I mean, you know, Shannon, it's difficult to reverse that because they don't like the courts don't like to touch the province of the jury. They heard this case. But if there's something, they're sort of like the eyes in the sky on an appellate court. They look down and they see, was there something that was given that was so harmful that it denied this defendant due process of law, that was so, you know, so egregious that there may have been a different result and require a reversal. Not easy to do, but I will guarantee you that, you know, they've built their record as best as they can. This judge's been a pretty tough judge.
Yeah, and Judge, having been in the trial a little bit more and watching it firsthand, any points you think would raise possibly for appeal here?
Well, let me go over the points I most commonly hear people speaking about and tell you what I think about them. The one that I hear a lot is, oh, the police did not read her Miranda warnings before they interrogated her over at Universal. The problem with that argument is twofold. One is she took them to Universal. She wasn't at the police station. She wasn't under arrest. Miranda warnings have to be given in a custodial interrogation setting. So the question is, was this a custodial setting? Because it was clearly, in my mind, an interrogation. You don't have to be under arrest for it to be custodial. However, they started the interrogation by saying, let's make sure we're clear. You are here voluntarily because you want to explain to us why you brought us here and what's really going on. So they kind of laid the framework for it not being custodial, for it being voluntary. Secondly, everything she said in there, which was admitted into evidence, is confirmed by the videotapes that are played of her speaking to her parents from the jail. So it's not like all of a sudden she gave some kind of blistering confession that the jury would never have heard had that not been admitted. What was admitted was basically cumulative of the story she stuck to with her parents. So to those who say that's reversible error, I completely disagree. Then you have the sniffer machine that they say is junk science, that Dr. Voss should not have been smelling the air in the trunk with this machine and telling us it had signs of decomposition. While I disagree, I think that it goes into the weight, not the admissibility of the evidence, because the methodology he used is proven and accepted, or the methods he used to determine the elements is proven and accepted for a long time. However, if you assume that it's junk science and it shouldn't have come in, you still have so much overwhelming evidence of decomposition that Baez is trying to pick apart now. You have all the people who smelled the decomposition, police officers, 2 canine dogs, Dr. Voss, the tow truck driver, George Anthony, that a judge is on the appellate court is likely to say, if it was error, it's harmless error. The one that I think comes closest to being a problem is that video that morphed into from Kaylee's face to a skull with the tape over it. That's a 403 analysis in Florida, which is a probative value versus prejudicial effect. And the question is, does the prejudicial effect substantially outweigh, or is it substantially outweighed by the probative value? And it is prejudicial, of course. It's kind of a shocking thing to see. However, the probative value was astronomical. The prosecution needed to show that this duct tape could have been used to smother Kaylee. And they were able to show it, and they had to use the skull because anybody could come in and say, well, you used a picture of Kaylee when she was smaller. And so she, of course it looks like it would cover her nose and mouth. So by using the skull superimposed on her face, they showed the eye holes matched, the nose matched, and the teeth matched. So yes, the face picture that we're using of her smiling is consistent with her size at the time that she died. And now they took the tape and they showed that one strand alone would cover nose and mouth. She was found with 3 overlapping strands. So while it was prejudicial and certainly shocking, it was highly, highly probative because it showed that this tape certainly could have smothered Kaylee. The only problem I would have had with it was including Casey in the picture. It was a picture of the two of them together, and it had Casey's face turned sideways and smiling, kind of like, you know, yes, I killed my daughter, haha, I'm smiling. I would have cut her out. I don't know if that's going to be enough to make reversible error.
Okay, and just to remind folks, we are now again waiting for the Casey Anthony trial to get back in session. The defense was in the midst of its closing arguments. We wait as you look at that door there to get the signal they're back. In the meantime, let's talk again with Bob Massi, our Fox News legal analyst. I want to ask you about the fact that everybody's focused on that first-degree murder, premeditated murder charge that Casey is facing, but there are other charges as well. If the jury can't agree on the big one, how likely is it in a situation like this they may come to a compromise on some lesser charges?
Yeah, I think that we're talking earlier with the judge, Shannon, that's where you get into that mitigating part of it. And that's what, obviously, that's what Bies is working on. If they, look, you know, you talk about that jury instruction about emotion. There's emotion all over this courtroom. There's going to be emotion in that jury room. You just cannot walk away from emotion, even with a jury instruction, because you take yourself as you find yourself in a jury room. Saying that, that's probably where, I mean, to whatever extent I have credibility even talking about this as to what's in people's minds, but if there's going to be a lay of the land where there's going to be a fight, that could be where it's at, where you have some that are going to say, and that's why I think Judge's great explanation about the duct tape. That was impressive to me this morning on the closing. You know, you have 3 duct tapes. I mean, that to me was like slapping across the face saying there was a premeditated act here, not to just shut her up, but to kill her. And then if there's enough evidence as it relates to mitigation, that's where the rubber may meet the road between jurors, where they say, yeah, we were willing, we're capital murder qualified here in order to hear this case, but we believe there's circumstances that mitigate it, therefore we can't find it was premeditated.
All right, Judge, I want to talk through some of these other charges with you and then talk about the sentencing as well and how that could happen if she is convicted. Of course, we've got the premeditated murder, the first degree. We've got felony murder with aggravated child abuse, aggravated manslaughter, aggravated child abuse separately, and lying to law enforcement officers. What kind of penalties is she facing, and who makes those sentencing decisions if she is convicted on any or all of those counts?
Well, the judge makes all of the sentencing decisions. The only thing is that if it is a first-degree murder conviction, either under felony murder or under premeditated murder, the death penalty is at play, and the judge's sentencing decision is with the advice of the jury. So the jury has to, during the penalty phase, make a recommendation as to whether they think the judge should sentence the defendant to life or to death. If it is not a first-degree murder conviction, the jury has no input at all on the sentencing. It goes exclusively to the judge. The quickest sentencing we would get is if she gets convicted of first-degree murder, and in the penalty phase, the jury recommends life. At that point, Judge Perry is not going to play around with trying to override the jury's recommendation. He's going to sentence her on the spot to life, and that'll be the end of it. If it comes down to second-degree murder, if it comes down to first-degree murder and they recommend death, the judge then has to have a separate hearing called a Spencer hearing for the attorneys to make additional argument and maybe submit additional evidence, and then has to go ahead and write a sentencing order and sentence, and that takes a little longer. If they come back with second, she's facing up to life. If they come back with aggravated manslaughter, she's facing up to 30 years. And if they come back with aggravated child abuse, I believe that's a second degree in Florida. It's up to 15 years. I'll have to check that. The lying to the police officer are each first degree misdemeanors. She faces up to 1 year on each. Any of these that she's convicted of, she can get concurrent or consecutive sentences. So the 1 year for lying to the police officer could become 4 years if she's sentenced consecutively.
And Judge, in Florida, I'm unsure, is there an automatic appeal if you do receive the death sentence? Has Florida taken a position on that?
There's actually an automatic appeal in every criminal prosecution. It doesn't matter if it's a cocaine possession or a death penalty case. The difference being that in a death penalty case, the defendant gets an immediate appeal directly to the Florida Supreme Court. They bypass the Court of Appeals and they go right to the Florida Supreme Court.
Actually sounds like a good idea that would save a lot of time and money for everybody who's involved in the appeals process.
Yes.
All right, Bob, so far in what you've seen from the defense, we know that they're going to get their shot at continuing to follow up on the closing argument. And you've noted that the prosecution can't come back and retry their whole case. They can only address points and positions that the defense took in its closing arguments. Anything that you've seen so far that sticks out to you that maybe even right now the prosecutors are thinking, all right, this is the point that we go after. We're prepping now for that rebuttal, which of course is the final word.
You know, for me, observing it this morning, the pictures on the board impressed me. I agree with the judge. I don't know why George Anthony's picture was remaining there except to sort of point the finger and say he was complicit in this. But, you know, sometimes, Shannon, a picture's worth 1,000 words, and that goes on both sides, because God knows there's horrible pictures of this beautiful little girl that was shown. But assuming what he said was accurate, and the evidence supported it, of those people that did not allegedly smell what was a decomposed body, I found that to be effective because, again, a picture's worth 1,000 words, and all of a sudden you have these 5 or 6 people, if it's true what he said, and I'm assuming it is because otherwise there'd be objections everywhere, you know, that when he said, look, that's reasonable doubt. I mean, but on the other hand, you have the DA that said, wait, there was a piece of hair that was 9 inches long, there was DNA, there is a match here. So the question is going to be that even though you have people that said it didn't smell like a decomposition, does the DNA science, and I've always said in these kind of cases, there's always that third witness in these cases of a circumstantial case, and that's science. And science is the third witness in this case. Yes, there's a lot of common sense. Yes, there has to be a lot of just life experiences, but that science in this case will in fact have a piece in the decision making. The one thing that I think the judge could answer this better than I could, but I understand, Shannon, that there is a jury instruction that's going to be offered that, paraphrasing, that circumstantial evidence in some fashion can be treated as direct evidence. Again, I would yield to the judge, and maybe he could explain, because that's my understanding, but I don't know if it's true or not.
Yeah, Judge, what is that particular instruction about? What impact does it have on the jury's consideration?
Well, if the circumstantial evidence instruction, which is not a standard instruction in Florida, has to be specifically requested, and it's at the discretion of the judge. But if the circumstantial evidence instruction is given to the jury, basically what it says is that a case can be proven by circumstantial evidence just as direct evidence. However, if there are 2 conclusions that can be equally drawn from the circumstantial evidence and the evidence does not eliminate every reasonable hypothesis of innocence, then the defendant has to be found not guilty. But what it doesn't mean, it does not mean that the defense can suggest, hey, it could have happened this way, and then say, there, I've offered a way it could have happened, therefore she's got to be found not guilty. As long as the prosecution does not have to completely rebut every possible scenario, all they have to do is put on competent evidence that contradicts the reasonableness of the defenses. And the defense's position, of course, is she drowned. The prosecution has already rebutted that by saying, wait a minute, children who drown are not found with 3 strands of duct tape across their mouth. The jury can decide if they think the drowning theory is reasonable.
All right, Judge Alex Ferrer, we thank you for taking out time for us. We know you got to get back into the courtroom, so thank you very much. Again, we are waiting for that trial to resume. Casey Anthony and the defense presenting its case in her favor. We'll bring Bob Massi back in here. Bob, I want to talk to you about the issue of sequestering a jury, because it's been weeks for these folks. We're now going into a holiday weekend. How does that affect a jury? Do they behave differently than when they get to go home every night?
Well, yeah, I mean, I'm sure they try to keep this jury as occupied as they can because it's a captive life, and jurors become friends, and, you know, they try to be as social as they can be, and I'm sure they're biting at the bit wanting to talk about this case. It's almost so cathartic for them, Shannon, when they finally go into the jury room. They say, thank God I can say what's been on my mind for the last 4 weeks. Did you see it that way? Did you see it that way? But it's tough, and that's why they're specially qualified, because, and that's why, by the way, the lawyers thank the jury, you know, that the sacrifice that they have made, all more the reason why they will not rush with this decision, because they know now, as the trier of the fact, that they have to take the evidence and put it to the law and make a decision. And many times, once they are in that room, one of the things that comes up, and I'm sure the judge would agree, and that is sometimes they don't understand jury instructions. And when they don't, they will send a note out to the bailiff that they need to talk to the judge or somebody needs to explain. And the judge, for example, could take a note from the bailiff that a question's being asked. And then they go to the attorneys, they let them know there's a question to be asked by the sequestered jury.
All right, Bob Massi, Fox News legal analyst, thank you so much for helping us evaluate this as we now still wait